If you are an immigrant living in the United States, if you have pending applications, if you have family members with uncertain status, what you're about to learn may fundamentally change how you think about domestic travel in this country. Reports have emerged confirming that the Transportation Security Administration is now sharing passenger information with Immigration and Customs Enforcement. This is not a rumor. This is not speculation. This is happening right now, and the implications for millions of people are significant. In this video, we will break down exactly what is being shared, how this process works, who is most at risk, and what this means for your ability to travel safely within the United States. Stay with me through the entire video because the details matter enormously, and the difference between understanding this correctly and misunderstanding it could affect critical decisions you make in the coming weeks and months. Let's begin with the fundamental question that many people are asking right now. What exactly is TSA's role, and why would they have any connection to immigration enforcement? The Transportation Security Administration was created after September 11, 2001, with a primary mission focused on transportation security. When you go through airport security, TSA officers screen you and your belongings to prevent threats to aircraft and passengers. This is the TSA most people know. However, what many travelers don't fully realize is that TSA also operates back-end systems that verify passenger identities before you ever arrive at the airport. When you book a flight, your information goes through the Secure Flight Program. This system checks your name, date of birth, and gender against government watch lists. It's the reason you receive a boarding pass with TSA Pre, or sometimes get flagged for additional screening. Here's where the recent developments become critically important. The information flowing through these systems has traditionally been used for security purposes. But there is now confirmed coordination between TSA and ICE that expands how this passenger data can be utilized. This represents a significant shift in how domestic travel infrastructure intersects with immigration enforcement. And understanding the mechanics of this shift is essential for anyone whose immigration status is not permanently settled. Now, let's get into the specifics of what we know is happening. According to reports and statements from government officials, TSA is providing ICE with access to passenger manifest information. This means that when flights are scheduled, ICE can potentially receive data about who is booked on those flights. This includes names, dates of birth, and flight itineraries. But this is where the situation becomes more complex than many initial reports suggested. The sharing of this information appears to be happening through existing legal frameworks that allow interagency cooperation for law enforcement purposes. This is not an entirely new authority. However, the scale and systematic nature of its current implementation appears to have expanded significantly. What does this mean practically? It means that if ICE has an interest in locating a particular individual and that individual books a domestic flight, there is now a pathway for ICE to become aware of that travel and potentially position officers to make contact at the airport. We'll discuss later in this video exactly which airports have seen increased enforcement activity and what patterns have emerged, but first, it's essential to understand who falls within the scope of this expanded information sharing. There's a critical misconception that needs to be addressed immediately. Some people believe that only those with active deportation orders or outstanding warrants need to be concerned. This understanding is incomplete and potentially dangerous. The reality is that the criteria ICE uses to prioritize enforcement actions have shifted over time and can shift again based on policy directives. While individuals with final removal orders have always been enforcement priorities, the current environment has seen expanded attention to other categories as well. This includes individuals who have overstayed visas, even if they have no criminal history. It includes individuals with pending immigration cases who have been released while awaiting hearings. It includes individuals who have previously been ordered removed but remained in the country. and it increasingly includes individuals who may have any form of immigration violation in their history, regardless of how long ago it occurred. Here's the question many people are not asking but should be. If you traveled into the United States legally, if you have been present for years, if you have built a life and a family here, does the manner in which you entered provide any protection against this type of information sharing? The answer requires careful consideration of your specific situation. Legal entry does not automatically mean current legal status, and current pending applications do not automatically mean protection from enforcement. These are nuances that matter enormously. Let me walk you through what appears to be happening at airports based on emerging reports. The pattern that has emerged involves ICE officers positioning themselves in secure areas of airports, often near gates or in arrival areas for domestic flights. This is notable because historically, most visible immigration enforcement occurred at international arrival points, not domestic terminals. What travelers are reporting is that after deplaning from domestic flights, they are being approached by officers who already appear to know who they are looking for. This suggests advanced knowledge of passenger manifests, which aligns with the reports of TSA information sharing with ICE. The encounters vary significantly. Some individuals report being questioned and released. Others have been detained. The outcomes appear to depend on multiple factors, including the individual's specific immigration history, whether there are any outstanding orders or warrants, and the specific directives officers are operating under. But this is where many people make a critical error in their thinking. They assume that because they have a pending application, or because they entered legally, or because they have never had any contact with immigration enforcement before, they are not at risk. This assumption can lead to decisions made without full awareness of the current landscape. So, who is most affected by these developments? Let me be specific. Individuals with final orders of removal who have not departed the United States are at the highest level of risk. If there is an order in your file instructing you to leave the country and you have not complied, your name may be actively flagged in systems that are now accessible in the context of domestic travel. Individuals who have missed immigration court hearings face significant risk as well. When you fail to appear for a scheduled hearing, a removal order is often issued in your absence. Many people are unaware that such orders exist in their files. If you have ever been scheduled for an immigration hearing and did not attend, you should take immediate steps to understand your current status. Individuals with prior deportations who have re-entered the United States face compounded legal consequences. Re-entry after removal is itself a federal crime, and ICE prioritizes these cases. But the scope extends beyond these clear-cut categories. Individuals with expired visas, individuals who have fallen out of status, individuals whose applications have been denied but who remain in the country, all of these populations now have reason to consider how domestic air travel intersects with their specific circumstances. And there's another group that many people don't consider: family members of individuals in these categories who travel together. While the enforcement focus may be on one family member, travel together means shared exposure to these encounters. What happens if you are approached by ICE at an airport? This is a situation where preparation matters significantly. The stress of an unexpected encounter with law enforcement can make it difficult to think clearly or remember your rights. Understanding in advance what to expect can make a meaningful difference. You have the right to remain silent. You are not required to answer questions about your immigration status, your country of birth, or how you entered the United States. You can clearly state that you are choosing to remain silent. You have the right to refuse consent to searches of your belongings beyond what TSA security requires. However, refusing to cooperate may extend the duration of an encounter and may not prevent officers from taking actions they believe are within their authority. You have the right to ask if you are being detained or if you are free to leave. If officers tell you that you are being detained, the situation becomes significantly more serious, and you should request to speak with an attorney before answering any questions. Document everything you can. Mental notes about officer badge numbers, the time of the encounter, what was said, and what actions were taken. This information can be valuable later. But here's what's most important to understand. Once you are in an encounter with ICE officers at an airport, your options are limited. The decisions that matter most are the ones you make before you ever arrive at the airport. This brings us to guidance for how to approach the current situation. I want to be extremely clear that this is not legal advice. Every individual situation is different, and the choices you make should be informed by consultation with a qualified immigration attorney who understands your specific case. What I can offer is awareness-level guidance about factors to consider. If your immigration status is uncertain, if you have any pending cases, missed hearings, denied applications, or previous orders, you should consult with an attorney before booking domestic air travel. This is not about living in fear. It is about making informed decisions. If you must travel, consider alternatives to air travel when practical. Ground transportation does not involve the same systematic identity verification that air travel requires. This is not a guarantee of avoiding enforcement, as ICE conducts operations in various contexts, but it reduces exposure to the specific airport-based information sharing we've discussed. Ensure that you carry documentation of any pending applications, approved statuses, or other official immigration documents. Having these documents immediately accessible does not guarantee a positive outcome, but it can help clarify your situation during an encounter. Have an emergency plan. Know the phone number of an immigration attorney. Have a family member or friend who knows your travel plans and can take action if you do not arrive as expected. These preparations may never be needed, but having them provides both practical protection and psychological peace of mind. Looking at this situation in broader context, what we are witnessing is a significant expansion of the intersection between routine domestic activities and immigration enforcement. For decades, domestic air travel was largely considered separate from immigration enforcement. You could fly from Los Angeles to New York without concern that your immigration status would become relevant. That understanding is now incomplete. This shift matters not just for those immediately at risk, but for the entire immigrant community. It affects how families make decisions about travel. It affects whether people feel safe visiting relatives in other states. It affects the psychological landscape of daily life for millions of people. And it's a reminder that the immigration system in the United States extends far beyond border crossings and visa interviews. It reaches into domestic infrastructure in ways that are not always visible until you encounter them directly. Let's bring this together with the key points you should take away from this video. First, TSA is sharing passenger information with ICE as part of expanded interagency cooperation. This means domestic flight bookings can potentially alert immigration enforcement to your travel plans. Second, the scope of who is affected extends beyond those with obvious enforcement priorities. If your immigration status is uncertain in any way, you should consider how this development affects your travel decisions. Third, encounters with ICE at airports are happening, and individuals report that officers appear to have advanced knowledge of who they are looking for. Being prepared for this possibility matters. Fourth, the most important decisions are made before you arrive at the airport. Consulting with a qualified immigration attorney about your specific situation is the most valuable step you can take. If this information was valuable to you, consider subscribing to this channel. We provide timely updates on immigration developments that affect the daily lives of immigrants, students, professionals, and families. In an upcoming video, we will discuss what rights you have during any encounter with immigration enforcement, whether at an airport, at home, or in public, and how to exercise those rights effectively. Thank you for watching. Take care of yourselves and each other. Stay informed, stay prepared, and approach these challenges with both caution and clarity.